For Timmins, James Bay.
Thank you, Mr. Speaker. As always, it's a great honor to rise in this House representing the people of Timmins and James Bay region, and I'm very proud to speak on the excellent work of my colleague from Abitibi Bay, James Nunavik EU, on his Bill C-641, an act that would ensure that the laws of Canada are in harmony with the United Nations Declaration on the Rights of Indigenous People. As I rise to speak today, 1,900 people from one of the communities I represent are being put in evacuation centres across the province in Saskatchewan. It was 10 years ago I sat at the table with the federal government, with the senior representatives and all the key bureaucracies, and watched a signed agreement, a promise to move that community. And when it came time to the chief to sign the piece of paper, we read the agreement, and all the verbal promises that had been made, none of them were in writing. And we were told, well, you can trust the honor of the Crown. And it shows the incredible power disconnect between the federal government with all their resources and an impoverished community that had to trust the goodwill of the Crown. Well, we saw the goodwill of the Crown. We saw the honor of the Crown. They ripped up the agreement. 10 years later, 6, 7, or 8 evacuations later, the trauma continues in Saskatchewan. And that is why we need to deal with this issue in the House of Commons, Mr. Speaker, because we're talking about the primary relationship on which this country is built. The primary relations is between the people who came here to settle and the Indigenous people who lived here. In many areas, that was signed in treaties. And it was the agreement that they told on James Bay and Fort Albany in 1905, that this agreement would last as long as the rivers run and the grass grows, and the rivers are certainly running on the Albany River right now. But the federal government refused to recognize its obligations. And there's an unbroken line of abuse from those times down to today through successive Liberal and Conservative governments, to the point where the Justice Department routinely brings forward bills without having even bothered to check if they are consistent with the basic treaty rights that are guaranteed under the Constitution. And the response from the federal government, if they're challenged on this to any First Nation communities, will take us to court, because they have endless pockets and they know that the communities that are standing up do not. And so it was very interesting in 2012-2013, the legal costs in the Department of Indian Affairs was $106 million, while the government spent only $66 million for legal costs at Canada Revenue and $37 million for legal costs for the RCMP. So are we to understand that they spent double, maybe triple, fighting Indigenous rights than they did going after international tax fraud and going after criminals? That appears to be the issue, Mr. Speaker. And it's not just issues of legal rights in terms of the land obligations to consult, because we see that every single time this government has gone to court, they have lost. There's an unbeaten string of victories, recognizing the obligation to consult, the duty to consult, the need to recognize the constitutional land rights of First Nation Indigenous people in this country. So why would we have a parliament that continues to pretend that those rights don't exist? I want to talk a bit about how some of these legal rights are being undermined. Not so much, we often talk about the treaties and we talk about the land rights, but in the rights of children. Canada is one of the 193 signatories to the Rights of the Child Convention. It is the most ratified human rights treaty in the world, and it provides obligations for each signatory state to guarantee rights of children. Now, Article 4 of the Convention requires that signatories, quote, take all appropriate of legislative, administrative, and other measures for the realization of the rights of children. This is something that the Justice Department, under this government, is very proud of. They are certainly willing to lecture other nations who signed this agreement. According to Justice Department website I was reading, it said, children deserve special attention because of their particular vulnerability. This is the modern concept of the child on which the Convention of the Rights of the Child is based. The best interests of the child shall be a primary consideration in all actions concerning children. In fact, the Justice Department says that signatories to this agreement can't claim domestic law supersedes the obligations of this international treaty. Now, this is very interesting that they take this position when they're talking about every other country in the world, but when it comes to Indigenous children in Canada, they have a bit of a different position. I have a letter that was sent from the Civil Litigation and Advisory Services of the Justice Department to the Human Rights Tribunal that's dealing with this government's systematic discrimination against Indigenous children. And they talk particularly about the UN Declaration on the Rights of Indigenous People. And it says, well, the Declaration is not a legally binding instrument. It was adopted by a non-legally binding resolution of the United Nations General Assembly. As a result of the status, it does not impose any international or domestic legal obligations upon Canada. So they will stand up and tell other countries that they have to protect the rights of children. But when it comes to protecting the rights of Indigenous children in this country, sorry, they will fight in court. They will spy on Cindy Blackstock. They will spend millions of dollars. They will do whatever it takes to deny children the most basic rights. So what rights are we talking about? Let's talk about the House of Commons standing. In this House, I was there December 7, 2007, on the rights, the Jordan Principle, because this federal government continually refuses to pay for basic medical care for children who are in care. They'll put them into foster care in the provincial system, but they won't pay for the most basic support. So in 2011, Marina Beadle of the Pictou Landing First Nation in Nova Scotia went to court to try and force this government to get home care for her badly disabled son, 16-year-old Jeremy Beadle. Now, Jeremy suffers from cerebral palsy, hydrocephalus, and autism. He only responds to feeding from his mother, and he can become physically abusive if other adults try to intervene. The mother is the only one that he responds to, otherwise he could die. She had to fight them in federal court for years. In fact, the Pictou Landing First Nations budget was going broke because they were trying to support this woman and her child at home. And the government lost. And the government lost because the courts noted that this federal government had stood up on the principle and stood up for Jordan's principle, and then yet had the nerve to go to court and fight its implementation. So the Beadle family won, Pictou Landing First Nation won, and this government appealed. Not only did they appeal, but they wanted the court costs of the federal government paid for by the family for having the nerve to stand up to them. Now, when that got out, they were forced to beat a hasty retreat because of the shame of people realizing they would go to this extent to go after a child who has the most basic issue of needs and support, and a mother who's just asking for what any other mother and any other community in this country would take for granted, the right to be able to look after her child in dignity. So we're talking about a fundamental breach that has existed, and that this government has been militant in ensuring this breach continues, which is the refusal to recognize the basic rights of Indigenous people in this country. But my colleague, who's done so much great work on this at the United Nations level, this is also about us recommitting ourselves to that relationship that goes back to the Royal Proclamation, that people could live in peace in this country. If you read the book Champlain's Dream, it's a beautiful book about Champlain, who left France and was tired of the violence and the civil wars and thought perhaps in Canada there may be a different way to build a nation. We have to restore that fundamental relationship because it is the relationship. It will continue regardless. And for my colleagues over in the Conservative Party who believe that they can continue to treat the peoples on reserves as some kind of hostage population who just stand in the way of access to resources, they're making a fundamental mistake. We will never be the nation we were meant to be until we restore that relationship. And we have to stop wasting the enormous dollars fighting the rights of people in court. We have to respect those rights. Those are the rights on which our nation is founded. Thank you, Mr. Speaker.